Hello and welcome to FFRF's Ask an Atheist. I'm Liz Cavell, Deputy Legal Director here at the Freedom from Religion Foundation. And this week we're talking about the Supreme Court's recent decision on a terrible case intended to restrict access to the widely used abortion pill, Mifepristone. So joining me today in studio is Sammy Lawrence, our current fellow who just last week accepted a full-time permanent staff attorney position at FFRF. So congratulations, Sammy, and welcome.
Thank you. It's great to be here in tropical Madison, Wisconsin.
Yes.
And I'm very excited to be staying at FFRF permanently.
Yes, we're so happy. And we have our legal director, Patrick Elliott, joining us remotely from Minnesota. Hi, Patrick.
Hi, nice to be with you. It's tropical here, too, if that makes you feel any better.
Yeah, it's the Great North, so we get really anxious when the weather gets legitimately hot and humid. So it's summer in the north. So our main discussion today is going to be following the ruling by the Supreme Court, which came down last week and was a unanimous decision throwing out the lawsuit that would have made the abortion drug Mifepristone so much harder to access. It was challenging the FDA's approval of the drug. And this ruling is great news for protecting reproductive rights in the U.S., and that's because more than 60% of abortions now are done through medication abortion, so the abortion pill. And Mifepristone is the most popular medication used for this procedure. It's the first of a 2-drug protocol that's used to terminate pregnancies. And thanks to how long it's been on the market and how long it's been regulated by the FDA, we're talking like a quarter century. It was approved in the year 2000. It is very safe, it is very effective, and so it's easy for patients to access, which is why it's been targeted by anti-abortion activists.
Yeah, exactly. So this case was brought by the Alliance Defending Freedom, a Christian Nationalist organization, on behalf of anti-abortion doctors who, like Liz said, wanted to challenge the FDA's initial approval of and then later regulations of Mifepristone. But even the Supreme Court, despite being a conservative supermajority, decided that the doctors lacked standing to challenge the FDA's decisions. And so the case has been remanded for lack of standing.
Right. So we've talked about standing on this show before, but obviously that means the court didn't reach the merits of the plaintiff's arguments at all about the FDA's regulations and whether it was lawful. This is all about whether they had the requisite threshold interest in the case in order to bring the case. So this was clearly an attempt by anti-abortion groups to use the high court to do their bidding and further erode reproductive rights for Americans. And that's, again, the Alliance Defending Freedom, the inaptly named because they're constantly trying to take freedoms and civil rights away and restrict other people's rights. So, Patrick, let's talk about why this case was so problematic to begin with and how it relates to church-state separation, both on the standing and the merits questions.
Yeah, you've already hit on the attorneys that took the case, Alliance Defending Freedom, but a lot of the plaintiff groups are these anti-abortion organizations that are collectively medical or otherwise related to healthcare field doctors who many of them identify as outwardly Christian, and they want to restrict abortion access. So the case was brought by these groups of doctors and then some of their individual members. And they've done a couple of things that are interesting. The first, which this is something we've all talked about, is they manufactured a case. They thought they aren't doctors who prescribe the drug. They don't regularly treat patients that take the drug. Sometimes they work in a facility that may have to treat patients for emergency room procedures and care. And so they try to use that to say, aha, we think this drug isn't safe and effective. Therefore, we might have to do more work, and that allows us legal standing to sue, which is, all absurd. If any of our organization or other civil rights groups tried to, kind of come up with this very tenuous causal chain, it would be a problem, right? So that's the first problem, is they tried to manufacture a case. And then the second one is where they took the case. This was filed very strategically in a one-judge district in the Northern District of Texas. And so the judge that it went before, Matthew Kaczmarek, is also likely a Christian nationalist, was appointed by President Trump, previously worked for a Christian organization very similar to Alliance Defending Freedom. And not surprisingly, he ruled in favor of the anti-abortion groups and said, I'm going to issue a total nationwide ban on this drug. So not just some of the protocols, complete ban. That was even too extreme for the very conservative Fifth Circuit Court of Appeals, which ruled in August of 2023 and said, well, we're not going to allow the outright ban, but we are going to restrict some of the FDA's more recent actions, which happened in 2016 and 2021. So that would allow for, like one doctor visit, telemedicine appointments, and restrict from up to 10 weeks gestation to 7 weeks. So the Fifth Circuit did that. Thankfully, the Supreme Court issued a block or a stay of that decision pretty quickly last year. And now we have this case. So that's kind of the background as to how we got where we got. But there's a lot of aspects that are troubling from the legal side and just from a policy side is that, are we going to have judges decide medicine in this way on this emergency basis and have the Supreme Court have to intervene, to save abortion access? That's really what happened in the last year.
Right. And I think you're kind of alluding to this, Patrick, which is, yes, the Supreme Court, I guess, did the right thing here and threw out a case that was putting forward a patently absurd theory of standing and theory of law. But I think it's important to note that this is no celebration for the American court system. This case should have been thrown out by several other lifetime appointed Article 3 judges along the way, and it got all the way to the Supreme Court. And, we heard oral arguments on this case. No part of this case needed to get this far. And so I think it's really important to understand that reflects a real problem with the sort of ideological bias of so many of the judges in our federal court system now, that they're doing this activist anti-abortion work through these cases that are totally set up and shopped into particular courts just for this purpose, when, the whole premise of the Dobbs decision overruling Roe versus Wade was that these were going to now become political questions that go back to the states. And the anti-abortion movement, mostly fueled by Christian nationalists, they're not satisfied with that because, of course, the majority of Americans are in favor of abortion access and choice.
Yeah, exactly. This case was bogus from the beginning and definitely should not have made it this far, which is something that FFRF pointed out actually in the amicus brief that we filed along with American Atheists, where we told the Supreme Court essentially that the standing in this case is manufactured and it doesn't exist, and the court really needs to reconsider the way it's been favoring just outright Christian, often Protestant plaintiffs in these arguments in certain key cases over the last few years. Patrick, do you want to talk a little bit more about our amicus with AA?
Yeah, I think, one thing, and we could do a look back and say, did we do the right thing in filing our brief? And I was looking this morning at what do the other groups talk about that filed briefs. At the Supreme Court, a lot of groups file these briefs. And I looked, and there were 35 friend of the court briefs on the side of the FDA. And only 4 of them discussed the issue of the standing of groups and how absurd it was. And that was one of our brief was one of the 4 briefs that did that. And I think it tracked with a lot of the opinion, basically laying out the idea that can you go to a federal court do you have a legal injury as a bedrock constitutional principle? The idea that what the doctors were really trying to do here was to restrict what someone else was doing. They weren't trying to free themselves up or actually alleviate their own harm. They wanted to block a drug that other people might use. And that tract with an opinion that Justice Kavanaugh actually authored for all 9 justices, as you said. So we highlighted in our brief the the standing problems, and then also what and we didn't label it this, but I think Kavanaugh also talked about it, was the idea of do doctors get super standing? Can a doctor sue over other people's injuries for things like automobile safety, pollution, and all of these types of things? We put that in our brief, and that's exactly what the court also talked about, the idea that that's not really based in any principles of American law, that somebody else can sue over another individual's injury. So I think overall, I would say I think our brief was very on point and helpful. And weirdly, I'm a little disappointed that there weren't more groups talking about standing, because the court obviously issued an opinion, and that's going to give guidance to lower courts, as to how this will work out. And then I also looked at what the briefs were on the other side. So on the anti-abortion group side, there were 38 friend of the court briefs filed, and only 6 talked about standing. So really, all of the people in the country want to talk about the issue of abortion, and we were, I think, savvy to talk about the issue of, wait a minute, these guys shouldn't be allowed to sue at all. We don't have to get to to the merits of the decision. So I think that was the right call with our brief here.
Right, and that was drafted primarily by you, Sammy, right?
Yes, Patrick and I primarily drafted FFRF's half of the brief. Jeff Blackwell from AA drafted half of the brief, but we all definitely provided feedback to each other and edits. The amicus brief drafting process when FFRF works with other groups is often very collaborative.
So as Patrick was mentioning about the points that seemed to be drawn out in the court's actual opinion, was sort of the court pointing out what we pointed out in our brief, which is if the court would accept this case and rule on the merits. In other words, if the court were to find that these doctors have standing to challenge the approval of Mifepristone just based on the possibility that they might someday in some future reality have to be called on to treat someone on an emergency basis who took Mifepristone, that inevitably kind of opens the door to all of these scenarios that Patrick was just talking about, where a doctor could challenge, some sort of governmental regulation or deregulation, like air quality. I think the court drew this one out, air quality regulations that might result in more patients having asthma, and then doctors might have to treat more patients. And all of this is speculative, which is the point of the court in rejecting that theory of standing. Our law requires a more concrete and non-attenuated injury that's also redressable, right? Because that's a big part of what was lacking in this case. Like taking Mifepristone off the market is such an attenuated, it's so far removed from what the plaintiffs are complaining about, both the causation, the FDA's action, and the redressability. So it was the right decision in this case, and it was definitely heavily argued by FFRF in our amicus brief. So we were pleased to see this opinion. So I think we've been asked and been wondering, why was this a unanimous opinion? Why did the court that just 2 years ago overturned Roe versus Wade, which was obviously a very activist opinion, why did they throw out this Mifepristone case? And we've talked about sort of the technical, right? What does the opinion say? And this case was totally bogus. Why do we think that this case didn't get traction?
That's speculation, obviously, but I think personally it might have to do with the fact that if they opened this can of worms, created this, extreme form of standing for doctors that could also, potentially be analogized to other professions too. There's nothing saying that this would only apply to doctors if they allowed this. It could both help and hurt causes that the justices do and don't like. There would be no principled way of saying this standing exists, but only for doctors who oppose abortion rights. I mean, there would just be no way to do that wouldn't just be them completely blatantly making stuff up.
Yeah, I do. I think that's right. Like, that's the face value, like, determination of, like, this case was not the proper vehicle for, further restricting abortion access by making some sort of ruling on abortion medication. What do you think, Pat?
Yeah, and I think with the Dobbs decision, obviously being so recent, they got what they wanted in terms of the religious right conservatives. States are banning abortion, and that would restrict the use of mifepristone in those states. And so that also kind of became an issue in this case. Is some of these doctors presumably are working in states where even taking it at the gestational age is illegal. So how are you having any injury that this is available on the market, that somebody might go to another state or get it via the mail from another country? And then I think it was all just too absurd. And it makes us, frustrating from FFRF side, because I think we have to take it seriously that the court might go along with what the parties are saying. Liz, we've also done a show after oral argument, and I think it seemed that our side, in terms of the standing issue, was going to win, but there were definitely justices that weren't. It was surprising to me that it was unanimous, I guess I would say. We have Justice Alito and Justice Thomas, who are not shy about reaching and grabbing issues that they want to talk about. I didn't see anything. I guess I'll ask you both too. I didn't see anything in the opinion that seemed to be an immediate, I don't know what you call it, a ticking time bomb that they put there. We just had the majority opinion, and then Justice Thomas did write a concurring opinion just on an issue about whether the associations can bring the case, which is not really super relevant to what we're talking about here. But that was good in a sense. So I don't want to celebrate this opinion. I think this is the court's doing the bare minimum, but they probably already got what they want, because abortion's being restricted all across the country, and they don't need to go after the FDA. And one other maybe cynical point on that regard is I think pharmaceutical companies would not like this. Like the idea that you can, anybody can turn around and sue and kind of second guess the medical judgment of the regulatory agency about making a drug more widely available or what protocols apply. So I think the standing decision is probably where you'd get a unanimous decision versus if you had to get into the merits, that probably wouldn't be unanimous. I think there would be dissents there.
Yeah, definitely. And just to go back to something Patrick said, a lot of states have completely banned abortion, and I think at least some of the individual doctors that we're suing in this case work and live in Texas, which has one of the strongest abortion bans in the country. I'm not even sure that you can prescribe mifepristone in Texas. I don't think you can. So that just made their argument even less plausible. You'd have to assume someone is breaking the law, before you can even get to the possible chain of events. And usually the court doesn't want to assume criminal activity as part of granting standing.
Yeah, that's such a good point. But I do think it highlights how this case, just the fact that this case was taken and that this is what the Alliance Defending Freedom is, spending time and resources cultivating and working on, just shows how radical their Christian nationalist agenda is and how far beyond Dobbs this movement is trying to go. Because we're not, as Patrick and Sammy are pointing out, we're not talking about states where post-Roe or post-Dobbs mifepristone is legal and they're trying to, somehow take down some last remaining vestige of Roe versus Wade. No, Roe versus Wade being gone means that all the states that want to completely ban or severely restrict abortion have pretty much already done so. There's many of them. And like those on the map you're seeing now, those orange states, abortion is banned. There's no getting a wide access to mifepristone in those states. So we're talking about a movement with Alliance Defending Freedom behind it that's trying to get at all the states that have chosen to protect or expand abortion access in the wake of Dobbs. And that is where they want to get Mifepristone off the shelves, because they've already gotten it off the shelves in the banned states, those orange states. And it shows how radical the movement is and how anti-democratic, right? When the court is saying, oh, we're just going to return this to the people through our states and through legislatures, the reality is that's not enough for the Christian Nationalist movement. They want to come for everyone's access to abortion, including in those blue states on the map.
Yeah.
And I did want to flag one, I guess this is more of a technical, so when the Supreme Court issues a ruling, it reverses and remands it back to the lower courts. And so here, I think we all think this is a good decision and it sets the right precedent. There's an oddity in this actual case where a few states, and I think it was Idaho, Mississippi, and Missouri, sought to intervene in the case, saying, hey, this injures us too. They were not parties, they were not actual parties before the Supreme Court. So my hunch is they're going to go back in the district court and argue, wait a minute, our injuries are differently. First of all, I don't know how, with the other parties getting kicked off, how this case could stay in Texas when you have 3 other states suing. It's a little bizarre, but and I'm not saying that they have legitimate claims, but to act like even the threat in this very case is over, it's not. I think we have a sigh of relief for now, which is what FFRF said in its release last week when this went out. But I don't think it's over. ADF and these other groups are going to keep pressing this, and they clearly have found judges who will go along with it. So even in those other states, like we saw on the map, some of those states like Idaho and Mississippi have this banned, but they're suing in court to otherwise restrict it in the states that it's not banned in. So it's certainly something that we are monitoring, and I think that just don't let it be a surprise when it comes out in the news in 3 months that these other states are still fighting in the court. That's what happens in the slow process of a case going back after a remand from the Supreme Court. So they will have a fight over whether those states can sue the FDA for their own claimed injuries here.
Right. In other words, those 3 states are, this case was dismissed only for the purpose of the plaintiffs that were before the Supreme Court. That's the anti-abortion doctors group and the individual doctors. Those 3 states are still parties, and they still have a live lawsuit, and they all go back to the district court before Judge Kaczmarek to decide what the fate of and argue over what the fate of the lawsuit is now that the plaintiffs are these states, these anti-abortion states. So, right. And of course, that's to say nothing of the other cases that are filed and constantly being developed and filed to challenge Mifepristone in all these different contexts and ways, right? This is a huge part of the Christian Nationalist movement. We've said it a million times in ways, but Dobbs was just the beginning, and there is not a sense of just leaving this to the states. It's a concerted effort to make all of the means of abortion access completely unavailable everywhere. And so these cases are going to continue in the courts because, of course, they can't, the Christian Nationalist movement can't affect these policies through the democratic process in so many of those states that you saw on the map. So I do want to talk a little bit about, Patrick, you mentioned no ticking time bombs, and I do agree with that. But I do want to say, the taking a step back and then my cynical take, which it always must be because this court is radical, and I've said it on the podcast and on this show that nothing comes free with this court. So there's no really good ruling that we should all be inspired that the court is just doing right by the American people and following the letter of the law. I do think this opinion follows the letter of the law in terms of what our standing law is, and that's great. But I did want to flag that the court has not yet issued its opinion in the EMTALA case, which we have talked about and we'll talk more about in a future show when the opinion comes down. But it's another case before the court that has to do with abortion treatment in emergency rooms. And it is the case that has the potential to kill, right? We're talking about emergency emergency room regulation, and we'll talk about it in a different case. But I do think it came up in the context of the Mifepristone oral arguments, and it kind of flagged for me and the other We Dissent co-hosts that maybe the court is kind of looking for a way to play these opinions off of each other. And one thing I think the Solicitor General said in oral arguments to kind of get through the bogus standing issues in this case is that EMTALA does not in any way compromise any emergency room doctor's conscience protections under the law, right? Like, in other words, a doctor, even an emergency room doctor who has a religious objection to participating in abortion care doesn't have to or can't be forced to participate in abortion care, even if they work in the emergency room. EMTALA being a statute that regulates emergency rooms, hospitals, and the type of care they have to provide all people, not just women who need pregnancy care, but it means that they have to provide life-saving and health-saving care to anyone that's in the emergency room. And what does that mean in states where abortion is banned, except to save the life of the mother? And what does it mean that the court is using this Mifepristone case to say EMTALA does not in any way mean that doctors, individual doctors, have to provide abortions? And I do think it could be fine, but I do think the court this term is not yet done affecting abortion access in the country. And I do think the case coming up, the EMTALA case, has the potential to have serious life or death consequences, even further than the abortion cases and rulings we've already seen in terms of emergency room care for women who either are pregnant or who have had abortions or who have had incomplete or failed abortions.
Yeah, definitely. Like Liz was saying, EMTALA, just to recap, any hospital that receives federal funding at all is subject to EMTALA, which requires that they provide people with emergency life-saving and stabilizing care regardless of that person's ability to pay. So it's not specific to abortion or pregnancy at all, and it's obviously a very good statute. And EMTALA was passed in the 1980s when Roe v. Wade was the law of the land. So we can assume that the Congress that passed and wrote EMTALA, they probably thought Roe v. Wade was always going to be the law of the land. They probably did not envision this world where there are states with total or near total abortion bans. And one of the states suing in the EMTALA case is Idaho, and the record in the case before the court is replete with tales of emergency room doctors saying that they have pregnant women in the emergency room who the only way to save their life or prevent them from having irreversible bodily harm that may leave them infertile is an abortion. But because the doctor cannot say with absolute certainty that the woman will die or be permanently harmed without an abortion, they are scared to perform the abortion because they could be fined or go to jail, lose their license and their livelihood. So women and pregnant people in these emergency rooms are being med-flighted to other states, and obviously care that they need is being severely delayed, and people are being seriously harmed, and some people are, in fact, already dying.
Right. And so the federal government is suing to basically clarify that EMTALA is the preemptive law of the land. In other words, even in Idaho or these states that have gone so extreme to ban abortion, except in the case of death, certain death, emergency rooms still have to abide by EMTALA and provide stabilizing care no matter what. And the court is hearing that case this term as well. We're awaiting an opinion in that case as well. So there's still a lot of damage that could be done to abortion access and pregnant people beyond just, what we thought was the end with Dobbs, or what we were told was the end with Dobbs, even though the access to the abortion pill lives to die another day in the United States.
Right. I think too I was correct in predicting that case was going to that the Mifepristone case was going to come down last week. Just the court has a lot of opinions still to release, but this one seems contentious and probably will be on the last day of the term, so the very end of June. So I'm hoping, Sam and Liz, that you'll be back in the first week in July, if that's when we are able to discuss and break it down. But I can also probably guarantee it won't be a unanimous opinion. I think we're going to get a very divided court on that. And also Alliance Defending Freedom, the group we've been talking about today, is also representing the state of Idaho in that case, which is quite absurd that a Christian nationalist organization is representing a state before the U.S. Supreme Court. So that's something to watch for. That's obviously not the end of abortion cases. And I think we're going to keep seeing these cases like this as states do more and more extreme things on the issue of abortion, that the courts, unfortunately, are our only thing saving some women, and that's not a guarantee with these courts. So that case very well could come down in an unfavorable way.
Yep. Looking into the future, and just to recap, right, this ruling means that the status quo kind of remains. Mifepristone will stay on the market. Of course, getting your hands on the abortion pill is still difficult or impossible depending on which state you live in, right? We saw the map earlier of states where medication abortion is completely banned, those orange states. And that's, for those of you who can't count fast like me, abortion is banned in 14 states. And in 15 states where it's legal, medication abortion drugs have to be prescribed by a doctor, not other clinicians like PAs and such. So, I mean, we already have a situation where medication abortion is severely limited or outright impossible to access for so many Americans across the country. But that crappy status quo is now safe from further incursions for now. Again, these cases are still being brought everywhere and in different contexts, and probably with better plaintiffs.
Yeah, that's the piece I do fear a little is, are the other side going to read? Again, I said I didn't think there was an obvious ticking time bomb, but they may scour that opinion and say, aha, if we only get doctors that say exactly this, now we've met this causation threshold and the standing injury threshold. So I'm not saying that, it's all over completely. It's obviously a very difficult course for the other side to continue to pursue this case. But I don't put it past them to try, or these other states that are still involved in the litigation, to try and kind of claim their own type of injury in order to restrict Mifepristone. So for now, I think we're in good shape right now. It's just they're going to be scouring that opinion to try to find ways to continue to press that issue. Yep,
good shape being a relative term. So I'm going to go to some of the questions that were pre-submitted on Facebook. We have just a couple, and just see if we can tackle them if we haven't already. So we already kind of talked about this, but do you think this is a significant blow to the Christian Nationalist opposition to bodily autonomy? In other words, you just touched on this, Patrick, but will this cause them to rethink their tactics? Or are they likely trying to find another way to ban these abortion drugs? So as we already talked about, there are many cases going at once that are still trying to tackle and restrict access to a medication abortion. And I honestly just think there is no end to the crusade to force a extreme conservative Christian view on when life begins on the rest of us. There is no end. Dobbs overturning Roe versus Wade was supposed to be the big culmination of this movement, and the amount of lawsuits and legislation and other actions that are being undertaken everywhere all at once to further and further and further restrict abortion access. And now it's not enough, right? We're going to contraception and in vitro fertilization, right? It's never enough until the full theology around life begins at conception is reflected in every single law of every single state. And so I don't think we're going to see any sort of self-reflection from the Christian Nationalist movement. This, I think, is just they take this as a come back, fix it up and come back and try again, right? Like just try to run better plaintiffs. The Supreme Court wasn't willing to go this far in this moment in terms of how deficient the standing was, but I doubt they'll be discouraged. Anyone disagree?
No. Well, I mean, the other thing they have is they have state legislatures. So that's what they've been doing since since Dobbs came down, is going through state legislatures and people kind of one-upping each other with more extreme legislation.
Right.
In terms of what exceptions might even apply to allow for an abortion. So that's the other piece. That's like, it's not just a court story. It's a legislature story too. What are states doing? They're restricting it in a lot of places, and that's unpopular, obviously, because a lot of when it's gone to voters, they've usually, or I think in almost every case, have approved of abortion in terms of their state laws and state constitutions. So it's a bigger issue than just who's going to take the next case, for sure.
Yeah, I mean, that's the thing. Dobbs happened, and it's been 2 years, and like, in terms of politically and like democratically, I think the anti-abortion, Christian nationalist movement has maxed out on where they can, through the democratic process, ban abortion, right? It's probably banned in all the states that it can be banned in democratically because the people will allow it. And so now the movement, instead of just being like, okay, our work here is done, it goes on and on and on to like push that fetal personhood, which is a theology, to push that to its furthest extent. And that's why we see these like crazy arguments and incursions into contraception and IVF and all the other places that involve, embryo, and these questions, these personal questions. So we touched on this a little bit, but I'm always game to talk cynic about the court. What do you think this decision says about the court as a whole? Do you think there's any hope they can deliver more decisions that are unbiased and beneficial to Americans? And of course, the fact that it's unanimous does some of the, in my view, kind of some of the credibility, cleanup work of the court, which I don't think benefits anybody, when the court can sort of pretend that it's credible and it's unbiased, I think that is a detriment to everybody because we've seen otherwise, and we know that this court is compromised. And look at all of the ethics violations we've seen, and the fact that this court refuses to be regulated or bound by any rules of ethics or overseen. Technically, the Senate can oversee and provide checks on judges, but the Supreme Court is definitely consolidated power to a degree that is harming democracy and most Americans. So I don't think anybody's benefited by these flickers of that we get in every term, where it's like, oh look, a unanimous decision that's reasonably based on case law, and we should all be so happy that the court is this fine institution. But what do you guys think?
Yeah, I don't buy it at all. I think it says a lot that when the opinion A actually did follow the law and was unanimous, I personally was very surprised.
Yeah.
I mean, based on oral arguments, I thought that it was probably going to be the right ruling, but I didn't think it was going to be unanimous, and I wasn't holding my breath at all for the court to do the right thing. I think anyone who has faith in the court to do the right thing is probably naive, and that the court is kind of trying to gaslight the country, or kind of give us this idea that, oh, look, we could do so much worse. You don't have to worry about
abortion. It's 2024.
Yeah.
It's fine. Totally. I think it's very much like the court, I think, for better or worse, this is the reality, which is the court has become, this ultra-conservative majority is a political actor. And so I view everything that happens in every term through that lens, which is they don't want to increase the salience of abortion pill access in this moment in time for whatever reason this year. And so they have taken a reasoned approach. They're not reaching the merits. It couldn't be easier to make this rule. This is the absolute most obvious way that this case should have been disposed of at the very beginning, which is these plaintiffs clearly lack standing under any theory that exists. So that's my view.
That's why I was a little guarded in looking at, and I don't know if our viewers like what they saw for headlines about this case, because we didn't think the court deserved like some pat on the back for doing the bare minimum. Obviously, they are trying to appear to be more moderate and are trying to do more consensus decisions, or at least 9-0 or 8-1 type decisions. So I do think that is a strategic decision by members of the court, because its reputation has taken a toll, which I think is rightfully done. So I do think that is a piece of why we got like one concurring opinion on a minor issue and not a lot of other people opining on it. I think the justices are realizing like this is not, they're trying to put out an appearance that they make, legal decisions based on precedent. And we may disagree on, whether they do that in most of their cases, but I think that's what they're actively trying to do on some of these cases. And then they're going to have the ones that they really, really want to do their damage. And that's where you're going to get, your 5-4 decisions or 6-3 decisions. So that's my, again, also cynical view, which Liz, you and I used to not always be this cynical about the court, but I think it's the reality watching it for the last 14 years. It's like, it's gotten bad. And
things
have
I think changed.
Yeah. I think the public is aware of it too, and they're not wrong in that observation.
That's right. Well, this last question is almost too sad to ask, but I have to put it out there in case anyone has a positive spin. Is it too positive to hope that someday, or it's possible to overturn the Dobbs decision? Is it at all possible to overturn the Dobbs decision, or is that being too hopeful?
I think it's possible to overturn it, but I don't think it will happen in my lifetime. I like talking to friends about this. I know that's probably not a positive spin.
No, that's horrible. You're extremely young.
But I think it's probably true. I've talked to friends about this, and I feel kind of like I'm a lawyer living after like Plessy versus Ferguson or something.
I totally
and
feel that.
My career is going to be attempting to lay the groundwork for the next generation to bring Brown v. Board of Education. And we can't give up, and we have to keep fighting, but we cannot be naive about it either.
I think that's right. I think it took so many decades of work by the Christian Nationalist movement and the ultra-conservative movement to overturn Roe versus Wade. And it shouldn't be that hard to course correct. It shouldn't be as hard to course correct, since the majority of the people in our secular democracy agree with the position of Roe versus Wade. So I do feel little hope there that things can change quickly, but not without reform, because when you have so much power consolidated in a way that the will of the people can't penetrate, it's really hard to make those changes. But we have a system of checks and balances. I say this all the time. The Supreme Court is just 9 people that we submit to their will. And there are other branches of government that, not just theoretically, but actually constitutionally, have the power to do oversight on not just the other Article III courts, but also the United States Supreme Court. They are not somehow, above the system of constitutional checks and balances. We can enact reforms. Our people's representatives can enact reforms that will rein in their conduct, their power, and that can be done. And so things can change quickly, but not without popular will and also good information reaching people.
Yeah, I think I agree with both of what you said. In terms of an actual opinion that is easily overturnable, it is if the court had the right members on it, because obviously, Roe had existed as precedent for, almost 50 years, and you have this court making a bad decision. I think it's easy in that way to overturn, but practically, I don't think we want to give people false hope that, it's just a matter of, this is going to just get fixed in a matter of a number of years. This is not an institution that changes to the will of the people, like we, elect a president and elect Congress people. This is an institution that really likes its precedent and wants to keep them for a very long time. So that's the thing that we're working against. But practically, I could see it getting overturned. It's just the win is the problem because of how undemocratic as an institution it is, which was in part designed that way, but maybe not with the idea of kind of how modern lifetime appointments have operated, with people getting a position that's unelectable for over 30 years, if not 40 years, for some of the justices. That's a problem. So I guess we're all gloom and doom on this, but I think it can get overturned. It's just the court does not have the right makeup, and I don't know when that would change, really.
But I have to say this again, it is within our constitutional structure to make those things happen. In other words, tell your representatives that you want court reform. Because, like Patrick said, in a lot of ways, our courts, our federal courts, especially our Supreme Court, was designed, I think, or envisioned by the framers to exist somewhat above the political fray. But I do not think it was envisioned that our courts would be completely drunk with power and unresponsive to the will of the people, no matter what they do. That is not what our framers had in mind. That is, I won't curse, but that is king stuff. That is not what the framers of the United States Constitution were about. They were about checks and balances, and our Senate, at least, and our representatives do have the power to check the United States Supreme Court in many ways. And you can tell your representatives that you think the Supreme Court needs to be checked. They need a code of judicial ethics, just like every other judge, sitting judge, and practicing lawyer in the entire nation, no matter where they practice or sit. They shouldn't be above the rules. We all have rules of professional conduct. Why shouldn't they? And the Senate is their boss. We're their boss. This is still a democracy. So that is the bare minimum. And there are bills that exist right now that would enact a code of ethics that would bind the U.S. Supreme Court. That's something you can call your representative and your senator right now and advocate. And then beyond that, the Congress has power over the court's jurisdiction. Congress has power over the court's makeup. Those things can be changed, and they can be changed at the speed of democracy, like Patrick said. Those aren't things we need to rely on the court to do. We just have to understand our own power and understand the reality of the situation, which is that the consolidation of power at the court has become completely anti-democratic, and it's harming people. So, on that note, I think that's going to wrap up this week's episode of FFRF's Ask an Atheist. Don't forget, we have a weekly radio show. It's Free Thought Radio. And this week, Dan Barker and Annie Laurie Gaylor will speak with Brian Rigg. He's the author of the new book, Japan's Holocaust, History of Japan's Mass Murder and Rape During World War II. They'll talk to him about the religious indoctrination that created such violent nationalism. You can find Free Thought Radio at ffrf.org/radio or wherever you get your podcasts.
And don't miss the latest episode of We Dissent, the only all-woman constitutional attorney podcast where you can listen to Liz and some other fabulous woman attorneys discussing constitutional law issues. You can find We Dissent wherever you get your podcasts and at we-dissent.org.
If you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. And if not, please join us. We will see you next week on FFRF's Ask an Atheist.